Okay. Supreme Court of the United States of America. Louisiana v. I don't know what this is. Calais? Gaiais? I don't know what the fuck this is, but appeal from the United States District Court for the Western District of Louisiana. Argued. I imagine that means oral arguments. On October 15th, 2025, decided 7 days ago. April 29th, 2026. Calais? Okay. These cases concern whether Louisiana's new congressional map is an unconstitutional racial gerrymander. In 2022, after the state redrew its congressional districts, a federal judge in Robinson v. Ardoin held that the 2022 map likely violated Section 2 of the Voting Rights Act of 1965, 52 U.S.C., blah, 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 because it did not include an additional majority black district. But when the state drew a new map, SB 8, that contained such a district, the new map was challenged as a racial gerrymander. A 3-judge court in... I need to hear how this is pronounced. I'm sorry.
Louisiana v. Calais is a test
Calais? The Daily Signal.
case, but the real...
The Supreme Court of the United States gutted the Voting Rights Act today. 6 justices, 1 ruling, 60 years of civil rights progress upended. In Louisiana versus Calais,
Calais? She says Calais? Calais?
People are talking about the latest Supreme Court ruling on the Voting Rights Act incorrectly. The Voting Rights Act was not gutted. And some people may say that this is just my pedantry talking, and it totally is, but there's a purpose to it. I think it's important that we understand exactly what happened here, because that is what is going to allow us to recognize where the problem actually lies and how we actually fix it. The largest vulnerability in our system is not...
Say the case!
The Supreme Court...
We will hear argument first this morning in Case 24-109, Louisiana versus Calais and...
Calais. All right, we'll say Calais. A 3-judge court in Calais v. Landry held that SB 8 violated the Equal Protection Clause of the 14th Amendment, and the state appealed to this court. If you want to read it along with Destiny and not this dog shit screen share, can you not read anything on my screen share? Because if so, I just won't even waste my time because it's annoying as fuck to me. If it's dog shit and it's not even...
You talking to me? I can read it.
No, this guy in chat is fucking crying.
No, I can read it on your stream too. This guy's retarded.
Okay. Let's just read this real quick. No voting qualification or prerequisite to voting or standard practice or procedure shall be imposed or applied by any state or political subdivision in a manner which results in a denial or abridgment of the right of any citizen of the United States to vote on account of race or color, or in contravention of the guarantees set forth in Section 10303F2 of this title. Shall be imposed or applied by any state or political in a manner which results in a denial or abridgment of the right of any citizen on account of race or color. A violation of subsection A is established if, based on the totality of circumstances, it is shown that the political processes leading to nomination or election in the state or political subdivisions are not equally open to participation by members of a class of citizens protected by subsection A, and that its members have less opportunity than other members of the electorate to participate in the political process and to elect representatives of their choice, and the extent to which members of a protected class have been elected to office in the state or political subdivision is one circumstance which may be considered, provided that nothing in this subsection establishes the right to have members of a protected class elected in numbers equal to their... Provided that nothing in this section establishes the right to have members of a protected class elected in numbers equal to their proportional population. Okay. Based on the totality of circumstances.
totality of the circumstances just mean like everything around it?
I don't know. That's legal language. That's going to show up in case law. I don't know how they treat that here. Like, I'm wondering what this means is that, like, if you were to make a district, like, let's say you have 10 districts and all of them are majority white, but you've got, like, a 20% black population in your race.
Yeah.
Does that sound like you could explicitly gerrymander and create a black district so that they would have some representation? Like, it sounds like that would be allowed.
Take them out of all of the other ones?
Well, I mean, you'd have to take some, but I'm saying it sounds like that type of racial districting would be allowed because you're not denying or abridging the right of any citizen. I don't know if that would count as a denial or abridgment of the white people in those districts. I don't know. Hopefully they talk about this in the case. Violation of subsection A is established if, based on the totality of circumstances, it is shown that the political process leading to nomination or election in the state or political subdivision are not equally open to participation by members of a class of citizens protected by subsection A, and that its members have less opportunity than other members of the electorate to participate in the political process and to elect representatives of their choice. Which may be considered. I see. Okay. So, denial of abridgment. Okay. Based on the totality of circumstances, I think means that you can violate subsection A without doing it deliberately. So if I were to create a bunch of maps and I were to base my district maps based on the number of rap music downloads, and doing that, I'm able to eliminate all black districts or something like that. I don't know. That would be considered a violation, I think, of this section because I didn't say black people, but I found a way to target black people or something like that, right?
That would make sense.
I believe that's what this means here.
Because you're still targeting them.
Kind of, yeah. Or you, in effect, if you consider the totality of circumstances, you've essentially abridged their right for that. Okay, I think. All right. The parties originally briefed and argued the suit last term, and their arguments at that time highlighted problems in the existing body of Section 2 case law. One problem resulted from the rule that in racial gerrymandering cases, unlike other cases involving claims of racial discrimination, strict scrutiny is triggered only if race predominated in the state's decision-making process. Another problem stemmed from the long unresolved question whether compliance with the Voting Rights Act provides a compelling reason that may justify the intentional use of race in drawing legislative districts. Oh, that was the thing I just brought up. For over 30 years, the court has simply assumed, for the sake of argument, that the answer is yes. Okay. These and other problems convinced the court that the time had come to resolve whether compliance with the Voting Rights Act can indeed provide a compelling reason for race-based districting. Okay. I feel like that's a little red flaggy, but I guess we'll see where we go with that. So one problem resulted. Okay, so up here, this is just saying that one problem resulted from the rule that in racial gerrymandering districts, unlike other cases involving claims of racial discrimination, strict scrutiny is triggered only if race predominated in the state's decision-making process. So the court will apply some level of scrutiny to a decision based upon what factors are at play, and strict scrutiny is the highest threshold that a state has to overcome to pass some kind of law. And they're saying here that strict scrutiny, as an analysis of whether a law can stand as legal or constitutional, legal, I think you would say, that's triggered only if race predominated in the state's decision-making process. But as long as race wasn't the number one factor, then there would be it's strict scrutiny, then down to intermediate scrutiny, and then rational basis. I don't know if it would be intermediate scrutiny or rational basis review. Basically, we just say that it would be easier for the state to pass their gerrymander or law, for broadly speaking. The scary thing that I don't like in here that's kind of weird is There's apparently a long unresolved question on whether compliance with the Voting Rights Act provides a compelling reason that may justify the intentional use of race in drawing legislative districts. For over 30 years, the court has simply assumed for the sake of argument that the answer is yes. So that sounds like, when I read that as a layman, it sounds to me like they're saying that for 30 years, that has been the assumption. And then they say, well, we're going to try to resolve that today. Sounds like the court wants to 180 on that. That's what that sounds like, which in my mind is an improper use of the court. Oh, thank God. William Judd. Destiny, I'm begging you to watch this link. We don't have to read the case.
Yes, listeners.
Oh, there's a YouTube video that just goes over for... Thank you. Thank you, William Judd. Oh, we can just watch this YouTube video.
Triple as.
Generally speaking, the Supreme Court shouldn't be overturning a whole bunch of case law precedent or making decisions that 180 the direction of the court, because it's not generally how our system of law works. You have a ton of different courts around the country that all kind of like look at different questions and they all kind of make rulings. And then over time, court decisions kind of establish this body of common law that like points towards a direction of like, well, this is probably how this law works as applied. Right? This is the kind of like the concept of like stare decisis or stare decisis, is that like there's a body of law that is all kind of decided upon, ruled in ordinary times by a variety of different districts applied to a variety of circumstances, and it would be exceptional for the court to 180 on that. But that might not be what this means. I could just be retarded. So, okay. All right. We will start with the syllabus. So the syllabus is not authored by an actual Supreme Court justice. The syllabus is just a review, a summary of the entire case that's written up by one of the clerks. So not the official opinion, but more or less summarizes what their decision is. So we can start with the syllabus. That's a stupid point. Precedent does not matter. The Constitution does. Judges take an oath to the Constitution, not precedent, LOL. So that's like a good point if you're 4 years old or functionally retarded, but precedent is incredibly important because singular judges are not the be-all and end-all for interpretations to the Constitution. You absolutely look to historical interpretations and the law as applied by a number of different courts or your own court in the past for guidance on how you ought to rule as a judge. Every single judge is not taking a fresh new look at the Constitution and a fresh new look at every single law in front of them in order to decide the constitutionality or not. It's not generally how it's supposed to go. That undermines the legitimacy of the court, because then it means nobody really knows what the court's going to say one day or the next, because a new Supreme Court justice might completely upend all of the constitutional interpretations of the current body of the current law.
Don't they usually just take cases and then they rule on that case, not like upend a part of the case that like everybody's been kind of like following under?
When I say upend, what I mean is they might change how they feel like the law should be applied. So one thing might be constitutional for a long time, and then the court might say, well, actually, we disagree. We think that past courts have gotten this wrong, including the Supreme Court, and we're going to say that this is not constitutional, or we're going to change our mind on a thing. Generally, you don't do that.
Like what they did in Roe v. Wade, right?
Well, like they did in... Fuck, what was it called? I can't remember the name of the case. God damn it! Dobbs, yes. Dobbs was overturning Roe and Casey, yes. Generally speaking, you don't do... stuff like
That's
that.
why it's a landmark case, right? It's like where people are like,
or
oh,
they'll call
this is a huge deal.
they'll call it a watershed case. Yes.
Got it.
So Plessy shouldn't be overturned because it was law for 80 years. So the one of the big reasons why they give for overturning Plessy was because I'm just making sure I'm not fucking this up. Plessy is where the separate but equal doctrine came from, correct? Let me just make sure. Yes. One of the big reasons why, if you read Brown v. Board of Education, it's like a 12-page opinion. It's very easy to read. One of the big reasons why they gave for upending Plessy is because the separate but equal doctrine in practice just didn't work. And part of the arguments that litigants were making was, look at the disparate outcomes, look at the disparate opportunity between black schools and white schools. Separate but equal as applied is not actually working here. That was one of the reasons, I think one of the biggest reasons that they overturned Plessy. Again, that's Brown v. Board, I think, is like a 12-page.
Not very long.
Yeah. I'm referring to SCOTUS. Any SCOTUS judge that makes a ruling based on precedent rather than actual constitutional interpretation is moronic. I don't know what to say to you. That's just not how judges, that's just not how constitutional law is viewed in the United States by serious people. I don't know what to say. Sorry. Okay. You're welcome to your opinion, though. Okay. Because the Voting Rights Act did not require Louisiana to create an additional majority-minority district, no compelling interest justified, the state's use of race in creating SB 8, and that map is an unconstitutional racial gerrymander. The Constitution almost never permits a state to discriminate on the basis of race, and such discrimination triggers strict scrutiny. The court's precedents have identified only two compelling interests that can satisfy strict scrutiny: avoiding imminent and serious risks to human safety in prisons, and remediating specific identified instances of past discrimination that violated the Constitution or a statute. Okay. God damn it. Hold on. I'm getting one guide.
So this is saying, like, we agree that if you're in prison and you're gonna get fucked over by like the gang of whites, like, we can segregate you.
Maybe, yeah. I'm getting one by a guy by an actual retard in chat. False. That isn't Brown v. Board opinion. LOL. I'm almost positive it is. That when they looked through the separate but equal stuff here, as applied, I think all the three underlying cases I think that made this. Status publication. In the South, the movement towards free common schools supported by general taxation had not yet taken hold. Education of white children was largely in the hands of private groups. Education of Negroes was almost non-existent, and practically all the race were illiterate. In fact, any education of Negroes was forbidden by law in some states. Today, in contrast, many Negroes have achieved outstanding success in the arts and sciences as well as business professional world. It is true that public school education at the time of the amendment had advanced further in the North, but the effect of the amendment on northern states was generally ignored in the congressional debates. Even in the North, the condition of public education did not approximate those existing today. The curriculum was usually rudimentary. Ungraded schools were common in rural areas. The school term was but 3 months a year in many states, and compulsory school education was virtually unknown. As a consequence, it is not surprising that there should be so little in the history of the 14th Amendment relating to its intended effect on public education. In the first case of this court construing the 14th Amendment, decided shortly after its adoption, the court interpreted it as prescribing all state-imposed discriminations against the Negro race. The doctrine of separate but equal did not make its appearance in the court until 1896 in the case of Plessy v. Ferguson. Involving not education but transportation. American courts have since labored with the doctrine for over half a century. In this court, there have been 6 cases involving the separate but equal doctrine in the field of public education. Cumming v. County Board and blah, blah, blah. Okay. The validity of the doctrine itself was not challenged. In more recent cases, all the graduate school level inequality was found in that specific benefits enjoyed by white students were denied to Negro students of the same educational qualifications. And then some cases here. In none of these cases was it necessary to re-examine the doctrine to grant relief to the Negro plaintiff. And in Sweat v. Painter, the court expressly reserved decision on the question of whether Plessy v. Ferguson should be held inapplicable to public education. In the instant cases, that question is directly present here. Unlike Sweat v. Blah, there are findings below. The Negro and white schools involved have been equalized or are being equalized with respect to buildings, curricula, qualifications, and salaries of teachers, and other tangible factors. Our decision, therefore, cannot turn on merely a comparison of these tangible factors. And the Negro and white schools involved in each of the cases, we must look instead at the effect of segregation itself on public education. In approaching these problems, we cannot turn the clock back to 1868 when the amendment was adopted, or even in 1896 when Plessy v. Ferguson was written. We must consider public education in light of its full development and its present place in American life. Today, education is perhaps the most important function. Compulsory school education. Today's principal instrument, blah, blah, blah. Because the question is, does segregation of children in public schools solely on the basis of race, even though the physical facilities and other tangible factors may be equal, deprive the children of the minority group of equal educational opportunities? We believe that it does. In this case, in finding the segregated law school for Negroes could not provide them equal educational opportunities, the court relied in large part on these causes are incapable to be measured, blah, blah, blah. Segregation of white. Yeah, this is what they go over this and they say that the separate equal doctrine fails. I don't know what this, I don't know why I don't know. Okay. Stop. Okay. I don't know why I'm getting one guide. Okay. Stop. Okay. Constitute a standard practice or procedure that may violate Section 2 of it. Okay, where are we at? The question presented is whether compliance with Section 2 of the Voting Rights Act should be added to this very short list of compelling interests. The court now holds that compliance with Section 2, as properly construed, can provide such an interest. A proper interpretation of Section 2 requires examining the statutory text to understand what it demands with respect to drawing legislative districts. Under Section 2A, the court takes as a given that a legislative districting map may constitute a standard, practice, or procedure that may violate Section 2 if it results in a denial or abridgment of the right to vote on account of race or color. Section 2B establishes that a violation occurs when political processes are not equally open to participation by members of a racial group and that they have less opportunity than other members of the electorate to elect representatives of their choice. The key concept is less opportunity than other members of the electorate, which sets a baseline against which to assess the opportunity of minority voters. That baseline, the opportunity that any given group of voters has to elect their candidate of choice, depends on the voting preferences of other voters in the district. Wait, what? The key concept is, well, I shouldn't interrogate this too much because it's just the syllabus, but that baseline, the opportunity that any given group of voters has to elect their candidate of choice, depends on the voting preferences of other voters in the district. I don't know why that would be true, but for example, in a district where most voters prefer Democratic candidates, a Republican voter in that district will have a low chance of securing the election of his or her preferred candidate. The roster of voters who end up in a given district depends, in turn, on the districting criteria the state uses to draw a legislative map. Thus, the opportunity of these members of the electorate to contribute their votes to a winning cause is whatever opportunity results from the application of the state's combination of permissible districting criteria. That is what a randomly selected individual voter and group of voters can expect regarding their opportunity to elect their preferred candidate. Under Section 2, a minority voter is entitled to nothing less and nothing more. Okay. Destiny,
Does this mean because, like, sorry.
Destiny, look up originalism versus textualism versus living constitutionalism. None of that means anything, and none of it matters. These are all memes that literally mean fucking nothing. I promise you they don't. What were you asking?
Does this mean because they can elect their representatives through, like, a state legislature / governor that they're not really worried about the maps? Is that what I'm picking up on in this paragraph?
It sounds like what the argument... I don't want to get into this too much because it's just the syllabus, but it sounds to me like what the argument here is, let's assume that every single black person is relegated to a district where they're like a super duper ultra minority or something. But let's say that they all vote for a Democratic candidate, and let's say the Democratic candidate like ends up winning. It sounds like they're saying then, well, basically, since they got to vote on the person who won anyway, then it's fine. That's what it sounds like the argument is here. But
yeah, okay.
That sounds really silly to me, but that might be, I don't know. But again, this is just the syllabus, so that's how it's summarized. So maybe Alito will make a better argument in here. I don't know. This interpretation is the best reading of the statutory text and ensures that Section 2 of the Voting Rights Act does not exceed Congress's authority under Section 2 of the 15th Amendment, which confers on Congress the power to enforce the amendment by appropriate legislation. As the court has long held, the 15th Amendment bars only state action motivated by discriminatory purpose. So a law that seeks to enforce the 15th Amendment by prohibiting mere disparate impact would fail to enforce a right that the amendment secures. So a law that seeks to enforce the 15th Amendment by prohibiting mere disparate impact would fail to enforce a right that the amendment secures. So the amendment secures the right to, let's look up the 15th Amendment real quick. Oh, easy one. The right of citizens in the United States to vote shall not be denied or abridged by the United States or by any state on account of race, color, or previous condition of servitude. And the Congress shall have power to enforce this article by appropriate legislation. Okay, so the court has long held the 15th Amendment bars only state action motivated by discriminatory purposes. Okay. So a law that seeks to enforce the 15th Amendment by prohibiting mere disparate impact would fail to enforce the right that the amendment secures. Oh, jeez. Okay, maybe. When was the Voting Rights Act passed? How did that comport with the 15th Amendment? Whew, Jesus, fuck. This is going to be a messy... we're not talking. There are no more additions when we talk about voting. I'm sorry. For Voting Rights Act, we're just talking about the 65 one. There's not like another like addition in 97 or some bullshit, right? We're just talking about. Okay. I wonder what the debate was at the time relating to the Voting Rights Act and the 15th Amendment. The amendment they're addressing is from 1982. What? I don't know what Bing is referring to there. Oh, wait.
He doesn't troll.
They added text in the 80s, which comes up in the opinion. Oh, from the Voting Rights Act is what I'm guessing is, but okay. All right. That is never appropriate because Congress cannot enforce a constitutional right by changing what the right is. For this reason, the focus of Section 2 must be enforcement of the 15th Amendment's prohibition on intentional racial discrimination. When Section 2 of the Act is properly interpreted, it imposes liability only when circumstances give rise to a strong inference that intentional discrimination occurred. Properly understood, Section 2 thus does not intrude on states' prerogative to draw districts based on non-racial factors, including to achieve partisan advantage. In short, Section 2 imposes liability only when the evidence supports a strong inference that the state intentionally drew its districts to afford minority voters less opportunity because of their race. Not only does this interpretation follow from the plain text of Section 2, but it is consistent with the limited authority that the 15th Amendment confers. Voting Rights Act, Section 2. How is this going to be a fucking huge read if I look this up, or? Oh no, this is just the thing that we read, Section 10301. I see, okay.
This whole thing is Section 2?
Yeah. Is established if, how does Alito, I can't wait to see what alchemy he uses to get rid of based on the totality of circumstances. He's going to find a way to get rid of that statement somehow. Okay. Because he's saying here that Section 2 of the Voting Rights Act would only apply when there is a... Where's my highlighter? Is this one the highlighter? Draw shapes. No. Highlighter. From the syllabus, it's saying Section 2 imposes liability only when the evidence supports a strong inference that the state intentionally drew its districts to afford minority voters less opportunity because of their race. But it sounds like Section 2 doesn't only require on intentionality. It sounds like it calls out explicitly totality of circumstances. But maybe he's going to view that differently or something. I don't know. We'll see. This interpretation does not require abandonment of the framework for evaluating Section 2 claims that the court established in Thornburg v. Gingles. The court need only update the framework so it aligns with the statutory text and reflects important developments since the court decided Gingles, I'm guessing this is Gingles, not Gingles, 40 years ago. 4 historical developments are of particular note. First, vast social changes occurred throughout the country, and particularly in the South, which have made great strides in ending entrenched racial discrimination. Second, a full-blown two-party system has emerged in the states where Section 2 suits are most common, and there is frequently a correlation between race and party preference. Okay. Third, in Rucho v. Common Cause, this court held that partisan gerrymandering claims are not justiciable in federal court, and this holding creates an incentive for litigants to exploit Section 2 for partisan purposes by repackaging a partisan gerrymandering claim as a racial gerrymandering claim. Fourth, the increased use and capabilities of computers in drawing districts in creative illustrative maps or illustrative maps means that a Section 2 plaintiff can easily identify an alternative map that fully achieves all the state's legitimate goals while producing greater racial balance, if such a map is possible. In light of these developments, the court updates the Gingles framework and realigns it with the text of Section 2 and constitutional principles. Fuck. How do you... I need to know how you pronounce this. Gingles case.
Multi-member voting districts, which are represented by multiple representatives, are larger in area and population than single-member districts. Thornburg versus Gingles.
Gingles. It is Gingles. Okay. Gingles. The first Gingles precondition is that a community of minority voters must be sufficiently numerous and compact to constitute a majority in a reasonably configured district. While many Section 2 plaintiffs have simply provided illustrative maps with their desired number of majority-minority districts, such maps prove only that the state could create an additional majority-minority district, not that the state's failure to do so violated Section 2 of the Voting Rights Act. To show the latter, plaintiffs' illustrative maps must satisfy two conditions. Plaintiffs cannot use race as a districting criterion in drawing illustrative maps. Is it illustrative or illustrative? Illustrative. And illustrative maps must meet all of the state's legitimate districting objectives, including traditional districting criteria and the state's specified political goals.
Illustrative.
Illustrative. It was illustrative. Okay. To satisfy the second and third preconditions, politically, this is just summarizing Gingles. It's not giving a new opinion on it, right? I think, but I don't know. Okay. To satisfy the second and third preconditions, politically cohesive voting by the minority and racial bloc voting by the majority, the plaintiffs must provide an analysis that controls for party affiliation, showing that voters engage in racial bloc voting that cannot be explained by partisan affiliation. And on the totality of circumstances inquiry, the focus must be on evidence that has more than a remote bearing on what the 15th Amendment prohibits, present-day intentional racial discrimination regarding voting, discrimination that occurred some time ago, and present-day disparities characterized as ongoing effects of social discrimination are entitled to much less weight. Nothing in Allen v. Milligan dictates a different result. That case merely addressed whether Alabama's novel evidentiary standard required a change to existing Section 2 precedent. Allen did not address whether race-based districting under Section 2 could extend indefinitely into the future, despite significant changes in conditions. Nor did it address whether Section 2 plaintiffs must disentangle race from politics in proving their case. Indeed, Allen did not address the 14th Amendment complaint at all, but here the decision before the court is based on the 14th Amendment. Under the updated Gingles framework, the facts of this suit easily require affirmance. Louisiana's enactment of SB 8 triggered strict scrutiny because the state's underlying goal was racial. The state configured District 6 to achieve a black voting age population over 50% because the Robinson Court held that Section 2 likely required the creation of an additional majority black district. The state's intentional compliance with the court's demands constituted an express acknowledgement that race played a role in the drawing of district lines. No compelling interest justifies SB 8 because Section 2 did not require the state to create a new majority-minority district. At every step of their Gingles framework, the Robinson plaintiffs failed to prove their Section 2 case. On the first Gingles precondition, the Robinson plaintiffs did not meet their burden because they did not provide an illustrative map that met all of the state's non-racial goals, including the state's political goals. On the second and third Gingles preconditions, the Robinson plaintiffs offered evidence that black and white voters consistently supported different candidates, but their analysis did not control for partisan preferences. And on the totality of circumstances, the Robinson plaintiffs failed to show an objective likelihood of intentional discrimination, instead relying on historical evidence and evidence that failed to disentangle race from politics. Jesus, okay. Alito delivered the opinion of the court, in which Roberts, Thomas, Gorsuch, Kavanaugh, and Barrett joined. Thomas filed a concurring opinion, oh boy, in which Gorsuch joined. And then Kagan will write the dissent, joined by Sotomayor and Jackson. Oh boy.
Is it normal to get that many, to get 3 opinions?
You can get a ton. You can get 9 opinions, depending on
they can
how
all
contentious
go?
the case is, yeah. Gingles Supreme Court case. Real quick. Let me just look at this real quick. 1986. Okay. It sounds like what Alito is going to make the argument of is that since black people, hopefully it's not this simple, but since black people tend to be Democrats, as long as Democrat voters are represented, in some way, then who cares?
Good to go.
Black people are fine. And if you try to make any more specific consideration relating to race to represent black people, that would be a violation of the 15th Amendment. Therefore, fuck you. That's what it sounds like. The argument is
like, it would be
gonna
like the right for citizens to vote shall not be denied. And is it saying like,
well, so the 15th Amendment is saying that like you can't deny people or abridge or make laws basically related to like race, basically.
race, color? Yeah.
And then the Voting Rights Act is saying that we can consider like a totality of circumstances when we're doing districting. So like if I create a districting thing that happens to disenfranchise every black voter, even if race wasn't a primary consideration, that's still bad. And we need to redistrict based on race to make sure that those people are represented as a racial group somehow. But it sounds like what Alito's going to say
district
in the statewide when drawing
state.
districts.
Okay.
Yeah. And then
that.
it sounds like what Alito is going to argue is that, well, if we look at black people, they all tend to vote Democrat anyway. So like even if you have no representation, as long as like Democrats can theoretically still win elections somewhere in your state, like it doesn't count as a discriminatory thing because you guys vote for Democrats anyway. So you're fine, which I don't know why. I don't know why we would even have. I don't even know why we would have this part of the Voting Rights Act at all. Then, but I don't know. We'll see. Okay, Justice Alito, one of our favorite crackheads in the court. Let's go. Section 2 of the Voting Rights Act of 1965 was designed to enforce the Constitution, not collide with it. Unfortunately, lower courts have sometimes applied the court's Section 2 precedents in a way that forces states to engage in the very race-based discrimination that the Constitution forbids. This tension between Section 2 and the Constitution came to a head when Louisiana redrew its congressional districts after the 2020 census. In 2022, somebody said it's worse than that because you can fuck over Democrats for partisan reasons. Well, you're allowed to do that. You can redistrict based, like, political party is not a protected class. So you can discriminate. Like, you can make a restaurant that says no Republicans allowed, no Democrats allowed. Like, that's not a protected class in the United States. So that's okay. We can say it's bad or we don't like it, but it's not illegal or against the Constitution, as I understand it. This tension between in 2022, a federal judge in the Middle District of Louisiana held that the map adopted by the state legislature likely violated Section 2 because it did not include an additional majority black district. But when the state drew a new map that contained such a district, its new map was challenged as a racial gerrymander. A 3-judge court in the Western District of Louisiana held that the new map, my guess is that the new map would be okay, even though it's a racial gerrymander, because it satisfies Section 2 of the Voting Rights Act, which in a roundabout way, kind of does hopefully satisfy the 15th Amendment, because we're creating this racial thing to get more racial balance and representation, et cetera, would be my guess is how they would have seen it, but we'll see. A 3-judge court in the Western District of Louisiana held that the new map violated the Equal Protection Clause. Never mind, they disagreed. And the state appealed to this court. The parties originally never mind. What I just said would have been the interpretation up to this time, but obviously this case is at the Supreme Court, so it would have been appealed to, I guess. Okay. A 3-judge court in the Western District of Louisiana held that the new map violated the Equal Protection Clause, and the state appealed to this court. The parties originally briefed and argued this suit last term, and the arguments at that time highlighted problems in the existing body of Section 2 case law. One problem resulted from the rule that in racial gerrymandering cases, unlike other cases involving claims of racial discrimination, strict scrutiny is triggered only if race predominated in the state's decision-making process. In this suit, Louisiana adopted the challenged map and created the second majority black district because it quite reasonably anticipated that, if it did not do so, the Middle District of Louisiana would order the use of a map with a differently configured second majority black district that would effectively oust an incumbent whom the legislature sought to protect. Under our existing case law, that situation posed the question whether race or politics was the state's predominant motivation. Okay. Another problem stemmed from the long unresolved question whether compliance with the Voting Rights Act provides a compelling reason that may justify the intentional use of race in drawing legislative districts. For over 30 years, we have assumed, for the sake of argument, that the answer is yes. And we have gone further and assumed that it is enough if a state has a strong basis in evidence for thinking that the Voting Rights Act requires race-based conduct. But allowing race to play any part in government decision-making represents a departure from the constitutional rule that applies in almost every other context. So, for over 30 years, I mean, this is just common law. This is a common law system. I don't understand, but okay, it's a good one, Chief. These and other problems convinced us that the time had come to resolve whether compliance with the Voting Rights Act can indeed provide a compelling reason for race-based districting. We now answer that question. Compliance with Section 2, as properly construed, can provide such a reason. Correctly understood, Section 2 does not impose liability at odds with the Constitution, and it should not have imposed liability on Louisiana for its 2022 map. Compliance with Section 2 thus could not justify the state's use of race-based redistricting here. The state's attempt to satisfy the Middle District's ruling, although understandable, was an unconstitutional racial gerrymander, and we therefore affirm the decision below. Jesus.
So it was a racial gerrymander because they wanted to include a majority black district?
Yeah.
Because they did it on racial lines?
Compliance with Section 2 thus could not justify the state's use of race-based redistricting here. He's basically, Alito's just arguing that Section 2 wasn't properly applied in this court case. So therefore it shouldn't have been used for this, to adopt this racial redistricting. So like, okay, follow me here.
Mm-hmm.
It sounds like what Alito's arguing here is he's saying what Section 2 is allowing you to do is if I can show you that you were racistly redistricting, then you're allowed to propose a different redistricting.
Yep.
Wait, hold on. Section 2, as considered before, said that if you can show in a totality of circumstances that there's been some kind of racial discrimination that has occurred as a result of your redistricting, then somebody can challenge your new map and say, hold on, this is in violation of the Voting Rights Act. You have essentially disenfranchised black voters by some roundabout way, basically. And what Alito is saying is, hold on, the only way that you can invoke Section 2 is if you can show that they intentionally were creating race-based maps and not that the race-based map was a byproduct of some other consideration. But it sounds like the way that the law, now this is my personal opinion, it sounds like the way that the Voting Rights Act was written, Section 2 allows you to consider the effect, not just the intention. That's why it says a totality of circumstances. But it sounds like Alito is saying that's bullshit.
You can only do it if they actually intended
and you have evidence of them intending it, yes.
So tomorrow, if Louisiana goes and redraws all their maps, and it's like, oh, well, sorry,
that's why I use the rap music example. They're just like, oh, we don't want to get people with rap music representation. If you were to challenge that and say, well, look at the Voting Rights Act, Section 2, you're basically found a way to disenfranchise black voters, Alito would look at that and go, nuh-uh, you can't challenge this.
Yeah, but aren't we going to get into like weird territory now where everything is like, oh, was this intentional or not? Doesn't this kind of just like fuck the legal system?
Well,
the lower courts?
Kind of. So my question would be, why do we even have this law then? I don't know why we would even have Section 2 as a law. Like that seems like
I guess it would just be for the intentionality behind it.
Well, but that's already illegal because of the Constitution, the 15th or 14th Amendment, I guess, as well, right? Equal protection. So I don't know. Yeah, I guess I'll keep reading. We'll see.
I'll keep going.
Somebody said, why do you sometimes stop reading or just sit in silence for like a minute? Because if it's heavy stuff, I'd have to think about it for a second. So I'm just reading words and not understanding anything. Okay. Fuck, I'm going to get triggered by this. That's okay. Ratified in 1870, the 15th Amendment provides that the right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of race, color, or previous condition of servitude. For many years afterward, however, states heavily suppressed the right of black citizens to vote. States employed a variety of notorious methods, including poll taxes, literacy tests, property qualifications, white primaries, and grandfather clauses in a blatant effort to suppress black voting. As an aside, this is one of the reasons why I don't like it when people compare like Israel to apartheid when people compare like, Muin Rabbani did this to me in my debate, comparing apartheid to Jim Crow, that Jim Crow was a type of apartheid. That's not true. States and other localities tried to fuck over black people by doing sneaky, underhanded shit.
Like Trump type shit.
Maybe, Trump is even more blatant. Whereas in apartheid, you just say, you're a subjugated racial group. You're literally just not allowed to vote. You're black, LOL. You're Indian, LOL. You don't get to vote. You're not part of the white people. That's why it's kind of stupid to compare Jim Crow, which is like finding clever abuses or ways to disenfranchise people, with apartheid, or like legalized segregation or disenfranchisement or unsuffrage. I don't know, whatever you say. Lack of ability to vote. This is a dumb comparison, I think, but okay.
Kind of downplays what was actually happening.
Well, downplays and misstates. It's just like a different type of thing, Yeah. Even as late as the mid-1960s, black registration and voting rates in some states were appallingly low. In addition, states employed legislative districting schemes to prevent the election of black candidates and candidates that black voters preferred. One question. I should know this. I never know this. When you draw a district in a state, is that only a congressional federal legislative district, or does that also like impact the state districts as well for like your state assemblies or your state legislatures? It's just federal. Okay, and that's okay. All right. Section 2 of the 15th Amendment authorizes Congress to enact appropriate legislation to enforce the amendment's protections, and in 1965, Congress invoked that power to enact the Voting Rights Act. The Act and its amendments in the 1970s specifically forbade some of the practices that had been used to suppress black voting, including literacy tests and poll taxes. Prohibiting the denial of the right to vote in any election for failure to pass a test. We upheld many of these provisions in Katzenbach. Blah, blah, blah. Okay. Section 2 of the Voting Rights Act, in its original form, closely tracked the language of the amendment it was adopted to enforce. At that time, Section 2 stated simply that no voting qualification or prerequisite to voting or standard practice or procedure shall be imposed or applied by any state or political subdivision to deny or abridge the right of any citizen of the United States to vote on account of race or color. In Mobile v. Bolden, the court interpreted this language, and 4 justices concluded, in a plurality opinion, that facially neutral voting practices violate Section 2 only if motivated by a discriminatory purpose. Justice Stevens, who concurred in the judgment, proposed a different but similarly demanding standard. Indeed, in his view, a districting practice, even if motivated in part by race, would not violate Section 2 so long as it was supported by valid and articulable justifications. Bolden roused an avalanche of criticism, both in the media and within the civil rights community. The 1982 amendments to the Voting Rights Act, a legislative history, blah, 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 quoting a book, critics argued that a focus on discriminatory intent rather than discriminatory effects would defeat worthy claims because of the difficulty of proving intentional discrimination. Members of Congress evidently shared these concerns. In 1982, shortly after Bolden, Congress sought to abrogate that decision by amending Section 2. A House bill was originally passed under a loose understanding that Section 2 would prohibit all discriminatory effects of voting practices and that intent would be irrelevant, but this version met stiff resistance in the Senate. Critics worried that an effects test would lead to mandatory racial proportionality in elections, a scenario regarded by many as intolerable. The House and Senate eventually compromised, and the final product included both an effects test in Section 2A and a robust disclaimer against proportionality in Section 2B. This latter provision also specifies that a plaintiff must establish to prove, or also specifies what a plaintiff must establish to prove a Section 2 violation. The provision requires consideration of the totality of circumstances in each case and demands proof that the political processes leading to nomination or election in the state or political subdivision are not equally open to participation by members of a protected class, and that its members have less opportunity than other members of the electorate to participate in the political process and to elect representatives of their choice. Congress took this language almost verbatim from Justice White's opinion for the court in White v. Register, which involved a vote dilution claim, i.e. a claim that a districting scheme impermissibly lessens the weight of the votes of minority voters. Look at this again real quick. Hold on. Okay. All right. Court affirmed a judgment. Okay. In White, the court affirmed a judgment that Texas had used 2 multi-member electoral districts invidiously to cancel out or minimize the voting strength of racial groups. According to White, a vote dilution plaintiff had to show that the political processes leading to nomination and election were not equally open to participation by the group in question, that its members had less opportunity than did other residents in the district to participate in the political processes and to elect legislators of their choice. The decision in White did not say anything. When it says this, do you understand what it means when it says this?
The decision in White or the above one?
So basically what it's saying is that do opportunities of a certain racial group in a state have the ability to meaningfully impact an election or choose their candidate in the way that other groups do in terms of race?
Yeah.
Is I think kind of what it's saying. So process leading to nomination, election, or equally open participation by the group in question. Okay. So by this interpretation, if I had a state that was 50-50 black and white, and I found a way to gerrymander it so that there were only 2 black districts, 2 districts where black people got their vote, and 8 districts where white people got their vote through clever gerrymandering, then that would be a violation of this law, of Section 2 here, because I found a way to kind of vote dilute away the black vote so that the black people don't have the same access to the political process to the white people. That would be how this would... Yeah.
But only if you did it intentionally now.
Well, now that's what Alito's going to make the argument of, I guess. But
that's what he's going to fight for.
We'll see.
But this is saying in White, that's what they were upholding. Or at least that's what they were under.
I think. Yes, yeah.
Okay.
The decision in White did not say anything one way or another about proof of discriminatory purpose or intent, but the court's rationale rested on evidence that gave rise to an obvious inference that the state had set out to prevent the election of candidates preferred by minority voters. The court's rationale rested on evidence that gave rise to an obvious inference that the state had set out to prevent. Okay. The Texas districting scheme generally used single-member districts. When you say single member, single racial member, that's what that means? Or single party member, racial member? The Texas districting scheme generally used single-member districts, but employed multi-member districts in 2 parts of the state, where single-member districts might have resulted in the election of minority candidates. The court observed that the use of multi-member districts is not necessarily, or per se, unconstitutional. Wait, one person elected from a single district, as opposed to a single district electing 2 people? But it recognized that such districts can be employed to achieve discriminatory ends. Wait, am I retarded? Are there districts in the United States that have multiple congressmen?
I didn't know that.
Not now. Oh, there used to be? Okay. I don't know. All right. Crazy. Wild country. But it recognizes such as can be employed to achieve discriminatory ends. Okay. In this case, observing that a switch to at-large elections could be a method to maintain white control of the political process, explaining that a change to at-large voting could nullify the choice or the ability of minority voters to elect their candidate of choice. The court also cited strong evidence that the legislature had done so in the case at hand. Writing at a time when the Democratic Party was dominant in much of Texas, the court noted that a white-dominated organization, which had effective control over candidate slating within that party, had engaged in racial campaign tactics in white precincts to defeat candidates who had the overwhelming support of the black community, thereby effectively excluding the black community from participation in the Democratic primary selection process. Alito cummed writing this when the Democratic Party was majorly racist. You know he loved to put that in. Okay.
Before the swap or whatever?
Kind of, yeah. The court likewise cited evidence that the legislature had invidiously excluded Mexican Americans from effective participation in political life, specifically in the election of representatives to the Texas House of Representatives. Thus, White presented a situation in which circumstantial evidence suggested very strongly that the state had created multi-member districts for the purpose of diluting minority votes. A few years later, when Congress looked for language that would abrogate Mobile v. Bolden's interpretation of Section 2, it included terms that were nearly identical to language used in White. The accompanying report of the Senate Judiciary Committee explained that the amendment's purpose was to repudiate Bolden and establish a new vote dilution test based on White. It's pronounced Mobile? Mobile,
Alabama.
This court first construed the amended version of Section 2 in Thornburg v. Gingles. Gingles concerned a challenge to North Carolina's multi-member districting scheme on the ground that it diluted the vote of black citizens. In 1986. I don't believe you that multiple representatives were... Hold on.
I don't even know what that would look like. Would that just be like a district that's so big they get like 2?
Oh, never mind. Multi-member districts are electoral districts that elect more than one representative to a legislative body. They're prohibited in the House of Representatives. As of when? Okay, whatever. You're lucky. All right. Gingles was decided at a time when this court often paid insufficient attention to the language of statutory provisions, and Justice Brennan's opinion for the court followed this pattern.
Well, he's shitting on like previous courts there, right?
Yeah.
Cringe.
Instead of analyzing what the statute said, the opinion simply quoted the text of amended Section 2 and then jumped right to the Senate Judiciary Committee report. Relying heavily on that report, the opinion set out 3 threshold requirements for proving a Section 2 vote dilution claim, plus a non-exhaustive list of factors to be considered in making a final decision as to whether the state had violated Section 2. To succeed in proving a Section 2 violation, Gingles taught a plaintiff must make 4 showings. Hold on. First, the plaintiff must show that the minority group in question is sufficiently large and geographically compact to constitute a majority in a reasonably configured district. A district is reasonably configured, we later explained, if it comports with traditional districting criteria, such as being contiguous and reasonably compact. Second, the minority group must be able to show that it is politically cohesive. Third, the minority must be able to demonstrate that the white majority votes sufficiently as a block. The minority group must be able to demonstrate that the white majority votes sufficiently as a block to enable it to defeat the minority's preferred candidate. Third, the minority must be able to demonstrate that the white majority votes sufficiently as a block to enable it to defeat the minority's preferred candidate. And finally, a plaintiff who demonstrates the 3 preconditions must also show, based on the totality of circumstances, that the political process is not equally open to minority voters. Okay. This is our Gingles test. So basically, we're looking at 4 factors here to say that Section 2 of the Voting Rights Act has been violated, according to Gingles. Gingles would argue that firstly, we have to be talking about like a real minority group that exists in a decent size and place. So like if you've got a state of 10 million people and you've got like a minority of like 27 like rare Chinese people, whatever, this is not like a voting group that's sufficiently large. Or if you've got like a state of 10 million people and there's like 100,000 Taiwanese people, or those would be Thailandish people, Thai people, but they're like scattered completely throughout the state. You couldn't realistically make a geographically compact district to represent these people. So you have to show that it's a sufficiently large group of people and it's in a geographically compact area. That's the first thing. And then the second is that the group has to demonstrate somehow that they are politically cohesive. So if it's like a 50-50 split on all of their voting across like multiple issues or candidates, then it would fail at that point. And then third, the minority group, third, they have to be able to demonstrate that the white majority votes consistently enough in order to defeat the minority's preferred candidate. So basically, all the white people are tending to vote in a certain way such that it's always going to, or at least is able to defeat the minority group's preferred candidate. And then if all three of these things have been shown, then then the final thing is a plaintiff who demonstrates the conditions must also show based on the totality of circumstances that the political process is not equally open to minority voters. I feel like the fourth thing would just follow the three, but maybe this is something there. But okay, that's the all right. In later cases, redistricting plans that states created to comply with the Voting Rights Act were themselves challenged as racial gerrymanders. This court approached such cases by building on the framework from other racial discrimination cases under the Equal Protection Clause. When we say Equal Protection Clause, we're talking about... It's always the 14th Amendment, right? Hold on.
The 14th is just everybody has like rights inalienable to them. Doesn't matter race, color, or what.
Well, we had a few things in the 14th Amendment, but the first is considered the Equal Protection Clause, I believe. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens in the United States or of the United States, nor shall any state deprive any person of life, liberty, or property without the... no, that's not it. I'm sorry. Hold on. Or wait, isn't it? Nor deny to any person... Oh, no, it is. Sorry. Nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. Okay. Really? The court challenged, the court approached such cases by building on the framework from other racial discrimination cases under the Equal Protection Clause. In those cases, if race played a role in a decision made by a government actor, strict scrutiny applied. Under this standard, the government needed to assert a compelling interest that justified its use of race, and if the analysis progressed beyond this point, the government had to show that its use of race was narrowly tailored to vindicate that interest. I believe the two key phrases here when you're looking at strict scrutiny cases is you're going to see compelling interest is going to pop up a lot, and narrowly tailored. If you ever see those phrases, you're usually looking at a strict scrutiny case. The court modified this framework for racial gerrymandering cases. Although any use of race in government decision-making generally triggers strict scrutiny, in gerrymandering cases, a challenger must show that race was the government's predominant consideration. And in cases where race predominated, states would sometimes assert that compliance with the Voting Rights Act provided a compelling interest justifying the use of race, yet we never decided whether compliance with the act could constitute a compelling interest. Instead, we repeatedly assumed, without deciding that the Voting Rights Act could constitute a compelling interest, because in all those cases, the act actually did not demand the state's race-predominant districting. Did not demand race. race predominant districting. Thus, the states in those cases could not satisfy strict scrutiny regardless of whether compliance with the Voting Rights Act could provide a compelling interest. Hold on. Consider compelling interest because in all those cases, the Act actually did not demand the state's race predominant districting. Thus, the states in those cases could not. Okay.
Is this kind of saying what he said in like the first paragraph or whatever? How they just like assumed for 20 years?
No. Okay.
I'm confused. Yeah.
All right. I think I'm seeing the path to get rid of that totality of circumstances. Okay, so if I make a law and the law says past 10 p.m., or past 10 p.m. there's a curfew or something, right?
Okay.
There's 3 levels of review, okay? Rational basis, intermediate scrutiny, strict scrutiny. This would be a law that it impacts everybody equally. It's not cutting against like some fundamental right. Hold on, let me bring up, just so I'm 100% getting these correct. Oh my fucking God, just give me the fucking picture! Hold on. I can't read that. Hold on. Kill yourself.
I'm holding.
Are we serious right now? If it's paywall, then why does it show up on the Google search thing?
Ask Grok to fix it.
God damn it. Okay. You can take a whole law class on going over this bullshit. But okay. So for rational basis, we're talking about like non-suspect classifications. So like all people, right? That's a non-suspect.
Yep.
It encompasses everybody. We're not talking about like fundamental rights, right? So like the right for representation or something like that, right? And it's just like a general legislation regarding social welfare. So like a curfew law, right? I don't know if right to movement, but like so rational basis basically just means if somebody challenges that law as constitutional, the court's going to look at that law, and the court's going to say, basically, can the state give me like any good reason why this should exist? And as long as the state can articulate some kind of like, yeah, we just think that like people kill each other past like curfew, it's not good. Basically, the court's going to like give it to you, right? Basically, every single law is expected to survive a rational basis review, unless the legislature is fucking retarded. You pass it, somebody challenges it, like as long as it's not a crazy class, not
it's pretty easy to pass.
100%. It would be expected.
It doesn't matter about your fundamental rights. All right, correct. We're understanding.
Yes,
got it.
So the second level of review is referred to as, sometimes people will call it intermediate scrutiny. I think I've heard heightened scrutiny, but intermediate scrutiny is the second level. So intermediate scrutiny is going to deal with quasi-suspect classifications. I think here they have genders and alienage. These laws, or it could deal with laws that are bartering, important, I can't read this, but not constitutional rights. I can't believe this fucking cuck shit.
Important but not constitutional rights.
Sure. Illegitimacy or gender? I don't know what the fuck illegitimacy is. But okay, whatever. So like, let's say that I make a law where I have like, we have laws where we can defend, somebody should tell me if this is actually true or not, like female-only gyms. I believe these are things that I think you can challenge, like the existence of these things for whether or not you're legally allowed to have these in existence. I think that might trigger an intermediate scrutiny review because you have a quasi-suspect class gender involved. And then in an intermediate scrutiny review, this one is considered by default against the government. The government would have to make, it would have to prove that there is a there's a substantial relationship between the class that's implicated and some important government interest here. So like I think the government could make the argument that we believe that having places where women can go to the gym and feel not harassed by men, that's a compelling state interest, and you obviously have to be able to defend the class of women there. So like this is why it's narrowly tailored to women, like and female gyms, like that's it, right? So you can have gyms narrowly tailored. It only applies to the gym. You couldn't make like a whole women's conference center or only women's or whatever. It just has to be a gym. There can't be like exclusive like business opportunities or crazy shit, right? It's a gym for women. There's a class that we've implicated. There's a reason why, and we have a compelling state interest to talk about it. This would be like an intermediate scrutiny thing, okay?
Would intermediate scrutiny also be for like your sexual orientation?
I don't know if orientation falls under intermediate or strict scrutiny.
Okay.
Strict scrutiny is when you are implicating some kind of like fundamental right, or if you're talking about like race, or like your ethnicity. Also, alienage might be like countries you come from as well. So if you're going to make a law, and this is a law that applies to like only black people or white people, or a law that like is preventing somebody from
like
voting,
the Muslim ban, right, or whatever.
Sure,
would be
yeah.
Under strict scrutiny. Okay.
This is going to be a thing where now you have to show two things. You have to show that there's a compelling interest, like a very, very, very compelling state interest that you're trying to further here, number one. And then number two, you have to show that the law that you've passed is like as narrow as possible, I believe, or at least like narrowly tailored enough such that you can't easily point to a more narrowly tailored one in order to advance this compelling interest. Does that make sense?
Yeah.
Okay.
Yeah.
Rational basis, easy. Intermediate scrutiny, hard. It's supposed to be against the state, but they can still do it. Strict scrutiny, very difficult. Sometimes in court cases, what the people are actually arguing on, they're not actually arguing whether or not they can pass some level of scrutiny. They're usually trying to argue for the scrutiny. So, for instance, when it came time to do the porn ban, not the porn ban, but whether or not laws that were mandating IDs for pornography consumers in states, whether or not these laws were constitutional, one of the terms that kept coming up a lot had to do with whether or not the material on pornography websites the majority of it was obscene. And the reason why they were trying to argue that the majority of it was obscene is because obscene material is not protected speech. You do not get First Amendment rights. It's very easy to attack obscene speech. That's a rational basis review. But if you say that it's not obscene, then it's a First Amendment protected speech right, and that would trigger a strict scrutiny review. So you might fight a lot on that case. And on that case, if you listen to oral arguments, the fight was whether or not it was obscene or whether or not it was First Amendment protected speech. First Amendment protected speech, the state would have to make a much more powerful argument and show that their restriction was much more narrowly tailored. Whereas if they just argue, oh, it's all obscenity. Well, obscenity, rational basis. You can basically make any argument you want to ban obscenity.
Yeah.
Make sense? Okay.
Yeah, that makes sense.
Okay. So
the lady on the playground calling like the kid the N-word, that would not be protected under the First Amendment because it's obscene speech?
Well, when we're talking about standards of review, we're talking about laws passed by the government that can be challenged by citizens. So what is obscene material?
Yeah.
I think like child porn, like I think like snuff films might be considered obscene, like showing people. I think hardcore pornography, I think, is considered obscene. I think. And I think hardcore pornography is considered like pornography where there's like where genitalia are visible. I think is considered hardcore, not like choking to death pornography, but just I believe. I'm not 100% sure on that. You'd have to look that up. Okay. So all of this aside, so when we do all of this aside, what Alito is arguing here, is Alito is saying that Section 2 of the Voting Rights Act can trigger states to say, hey, you've managed to disenfranchise a group of minority voters as determined by the Gingles test. We've demonstrated, we've met these four elements. You've disenfranchised a group of voters. So now what you need to do is you need to go back and you need to draw another map with racial considerations in order to satisfy Section 2 of the Voting Rights Act. But what Alito is saying is, hold on here. Just because you satisfied Section 2 of the Voting Rights Act, that doesn't mean that you passed the strict scrutiny hurdle. So actually, the strict scrutiny hurdle is a hurdle that would be above just satisfying Section 2 of the Voting Rights Act. And it sounds like that's the ground that he's going to argue on. So he's going to say
that you have to show me proof that they did it on racial ties on purpose in order to hit the strict scrutiny. Yeah.
He's going to say that in order to do it, you have to show a compelling state interest, and saying that you satisfy Section 2 of the Voting Rights Act, that's not enough, and that it's narrowly tailored as much as possible. So rereading this paragraph now, the court modified the framework for racial gerrymandering cases. Although that framework that he was talking about was the rational basis review framework, okay? That's what we just went over. Although any use of race in government decision-making generally triggers strict scrutiny, in gerrymandering cases, a challenger must show that race was the government's predominant consideration. So saying here that, like, generally, if the government is ever considering race at all, it's going to be a strict scrutiny review in order for the law to pass. In gerrymandering cases, though, a challenger has to show that race was the predominant consideration, not just any, but the predominant one. And in cases where race predominated, states could sometimes assert that compliance with the Voting Rights Act provided a compelling interest justifying the use of race. So a compelling interest for why they had to use that class. Yet we never decided whether compliance with the act could constitute a compelling interest. Instead, meaning would that be enough to surpass the strict scrutiny ruling? Instead, we repeatedly assumed, without deciding, that the Voting Rights Act could constitute a compelling interest because in all those cases, the act actually did not demand of the states race-predominant redistricting. So saying that the Voting Rights Act didn't actually say that you had to use race when it came time to redistrict, meaning that we never applied the rational basis review to the entirety of the Voting Rights Act. And then thus, the states in those cases could not satisfy strict scrutiny regardless of whether compliance with the Voting Rights Act could provide a compelling interest. So he's just saying that you need to pass a strict scrutiny review, I believe, in order to assert some new maps. And you can't just say that, like, for your compelling state interest, the compelling state interest can't just be complying with the Voting Rights Act. You have to do, I believe, a step above and beyond.
Yeah, that's making sense now. I see where he's going.
What's up? Zip zip.
Hold on. Can you hear me?
Yes.
Just a quick thing. You said earlier that you're saying that Alito wants to get rid of the part totality of circumstances because then you can...
Well, maybe. That was a prediction I made, but I have no idea if that's going to pan out or not because I'm still reading the decision. But that was it felt like he was going to try to get rid of that.
So sure. So just real quick to kind of... And it's already been kind of explained. I think you read it a little incorrectly. What they're saying with the part of the totality of circumstances is the part that helps Alito in his argument in this case. Because based on Section A...
Well, here, wait, we'll get to that. He hasn't made that argument at all yet. When I get to that, I'll read it. I don't think we've gotten to that yet, though. I don't even know if he's used totality of circumstances yet. That might have been in the syllabus, but I'm reading through the opinion. I'm sure he'll get to that in the opinion, though. Okay.
It was in syllabus.
Yeah, but syllabus, I'm not interrogating the syllabus text because Alito will make the argument in long form in the actual opinion. So. Okay, I love you.
I'm just going to hang out because you're triggering me.
Good.
Listen to this.
In later cases, redistricting plans that states created to comply with the Voting Rights Act... we already read this. Where were we? The court modified the framework for racial gerrymandering cases. Okay, we just read this as a whole thing we went over. Instead, we repeatedly assumed, without deciding, that the Voting Rights Act could constitute a compelling interest because in all those cases, the act actually did not demand the state's race-predominant redistricting. Thus, the states in those cases could not satisfy strict scrutiny, regardless of whether compliance with the Voting Rights Act could provide a compelling interest. Regardless of whether the Voting Rights Act could not satisfy regardless of whether race-predominant. Okay. The first case in which the court explicitly made this assumption was Miller v. Johnson, which concerned a majority black district. Let me just summarize real quick at the end of that. So, thus, the states in those cases could not satisfy strict scrutiny, regardless of whether compliance with the Voting Rights Act could provide a compelling interest. So they're saying here that, like, even if the Voting Rights Act did provide a compelling interest, that doesn't necessarily mean that... Thus, the states in those cases could not satisfy strict scrutiny, regardless of whether compliance with the Voting Rights Act could provide. So even if the Voting Rights Act could provide a compelling interest, that's not necessarily an argument that the maps that they were passing were narrowly tailored enough to pass a strict scrutiny review, is what that means. Because and then in the sentence earlier, that the act didn't demand the state's race-predominant redistricting. Okay, all right, okay.
He's basically saying, like, well, we never made a decision that it would pass compelling interest, right?
Because he's saying that the act itself doesn't say, well, in order to satisfy the Voting Rights Act Section 2, you have to pass a racially dominant map. You don't have to do that. He says that because the act itself didn't provide for that language, that this is an analysis that these prior courts and future courts need to be doing. Yeah. We'll get more of that. Okay. The first case in which the court explicitly made this assumption was Miller v. Johnson, which concerned a majority black district that was designed to satisfy the Justice Department's pre-clearance demands under Section 5 of the Voting Rights Act. The Miller court first found that the legislature had subordinated traditional race-neutral districting principles, including but not limited to compactness, contiguity, and respect for political subdivisions or communities defined by actual shared interest to racial considerations. The Miller court first found that the legislature had subordinated traditional race-neutral districting principles. Okay. For this reason, the court held race had predominated in the creation of the new district, and the state had to demonstrate that its districting legislation was narrowly tailored to achieve a compelling interest. The court... Okay, hold on, let me reread this. Jesus. The first case in which the court explicitly made this assumption was Miller v. Johnson, which concerned a majority black district that was designed to satisfy the Justice Department's pre-clearance demands under Section 5 of the Voting Rights Act. The Miller court first found that the legislature had subordinated traditional race-neutral districting principles, including, but not limited to compactness, contiguity, and respect for political subdivisions or communities defined by actual shared interests to racial considerations. Had subordinated these to racial considerations. For this reason, the court held race had predominated in the creation of the new district, and the state had to demonstrate that its districting legislation was narrowly tailored to achieve a compelling interest. Okay, so they're saying that you were using race as a predominant factor for why you created this new districting map, and because of that reason, now you have to pass a strict scrutiny threshold. The court declined to address whether or not in some cases compliance with the Voting Rights Act, standing alone, could provide a compelling interest, independent of any interest in remedying past discrimination. Instead, the court explained that the challenged district was not reasonably necessary under a constitutional reading and application of the Voting Rights Act, so the state's goal of complying with the act could not supply a compelling interest. The challenged district was not reasonably necessary, constitutional reading and application of the Voting Rights Act. Whether or not in some cases.
So just because you comply with the act doesn't give you compelling interest.
Well, hold on.
Is what he's saying.
The court declined, he's saying in this Miller case, the court declined whether or not in some cases compliance with the Voting Rights Act standing alone could provide a compelling interest, independent of any interest in remedying past discrimination. Instead, the court explained that the challenged district was not reasonably necessary under a constitutional reading and application of the Voting Rights Act, so the state's goal of complying with the act could not supply a compelling interest. It seemed like the court said that it wasn't necessary. The challenge district wasn't necessary, and therefore it wasn't necessary even as reading the Voting Rights Act, and therefore
it wasn't necessary to comply with the Voting Rights Act.
Yes.
So if you say that that's why you're doing it, it doesn't apply.
Sure. Yes. Challenge district was not reasonably necessary under a constitutional reading and application of the Voting Rights Act, so the state's goal of complying with the act could not supply a compelling interest. Okay. So, like, if I were to say I need to create a new district, and I'm trying to get all of the Destiny voters in one district, and I'm trying to say that, like, well, look, isn't there, like, some racial discrimination or something? So we want to rebalance the district here, whatever. And then I put all the Destiny voters in one state or one district. But I can see that, like, any reasonable reading of the Voting Rights Act and the way that you've redrawn this district, it doesn't seem like you are putting people here, you know, with a fair reading of the Voting Rights Act. So that can't count as your compelling interest. That wouldn't be a strict scrutiny review, but so, okay. State's goal of compelling interest. Okay. Sorry. Okay. All right. We repeated much of the same analysis in Shaw v. Hunt, applying strict scrutiny to a redistricting plan that a state crafted to comply with both Section 2 and Section 5 of the Voting Rights Act. Once again, we did not reach the question expressly left open in Miller, whether the Voting Rights Act could itself provide a compelling interest to justify race-predominant districting. After assuming, arguendo, for the purpose of resolving this suit, that compliance with Section 2 could be a compelling interest, we held that the plan failed strict scrutiny because it was not reasonably required under a constitutional reading and application of the Voting Rights Act. Likewise, in Alabama, Legislative Black Caucus v. Alabama, we applied strict scrutiny to a race-predominant districting plan that the state had created for two purposes. First, to come close to a one-person, one-vote ideal, and second, to ensure compliance with Section 5 of the Voting Rights Act. We held that, even if the Voting Rights Act could provide a compelling interest, the map did not satisfy strict scrutiny because it was not required by the Act. Once again, we left open whether compliance with the Act remained a compelling interest. Okay.
I don't understand this last one. Because it was not required by the Act. What does that mean?
The same.
So it sounds like
basically
it's
they're
saying, basically what it's saying is that, like, let's say that, like, do you feel like you can explain this concisely, Subzip?
Yes.
Okay, go.
Yes. So basically it's saying, in each of these cases, they're basically saying the same thing for all these three cases. Saying in each of these three cases, what ended up happening was they did a strict scrutiny test, and it's saying even if Section 2 of the Voting Rights Act did let you do strict scrutiny versus not allowing you to do that or having you do a rational basis or whatever, even if it was strict scrutiny, it wouldn't you wouldn't pass it. So we're tossing it.
But he's not explaining why they wouldn't pass it. Is that just explaining the
in this
case?
they're not. No, and because that's not the important part for the point that he's making in this point.
Okay.
It sounds like what he's saying
The important part is that they left it open. They said if it was strict scrutiny, not it is strict scrutiny, therefore that's why you lost.
Well, so it sounds like so strict scrutiny requires two things: narrowly tailored and compelling interest. And in all of these cases, it sounds like what's happening is the assumption by the state legislature is that if it satisfies the Voting Rights Act, that would count as a compelling interest. However, in all of these cases, it was ruled that they didn't satisfy the Act, therefore they got struck down. But it sounds like what Alito is saying is, but we didn't actually ask the question of, well, if they would have satisfied the Voting Rights Act, does that even make it a compelling interest? So it sounds like basically, like, let's say that if you're taking your mom out to eat, and in all three cases, like you and your mom, your dad passed some agreement, and it was like, mom needs a steak dinner in order to be happy. Okay, trust me, wink, wink, nudge, nudge. Now let's say you take your mom out to eat at McDonald's, and then you go to Wendy's, and then you go to Burger King. Well, let's say that you go back home, and your mom is like, well, do you think this was a good time or whatever? And then you go to your dad, and your dad is like, well, did you take her out to a steak dinner? And you look at all of the three places you took her, and they were all fast food places. And you're like, okay, well, actually, I didn't take mom out to a steak dinner for any of these. So it actually, like all of these sucked. It didn't work. All of the dinners were bad. Okay, they got struck down. Yeah. But what mom is saying in the background is, even if you did take me out to a steak dinner, I'm not even sure if that would have been good enough. But you didn't even take her out to a steak dinner, so we didn't even get to address that question. We didn't even get to touch that. So for the Voting Rights Act here, they're saying, according to the Voting Rights Act, that maybe you need to have a race-based district in order to satisfy the Act. And in all three of these cases, they failed to do that. It didn't even satisfy the Act. But the state legislatures were trying to satisfy the Act because they thought that would count as a good dinner for mom. They thought that if they satisfied the Act, then that would be a compelling interest, which would survive strict scrutiny. But what Alito is saying is, even if you took your mom out to get a steak, even if you did satisfy what was required by the Voting Rights Act, we don't know if that actually counts as a compelling interest as insofar as strict scrutiny is concerned. So that question is kind of open, basically, on whether or not the Voting Rights Act could require a race-based redistricting, or if there'd be another test you would have to apply, I think, yeah. Jesus, fuck all this shit. All right, hold on. In Cooper, we continued our long-standing assumption that complying with the VRA is a compelling interest. Again, we did not need to resolve this question because a constitutional reading and application of the Act did not require the district at issue. I just had a fucking brain blast moment where I'm understanding maybe why dicta or why court justices will sometimes opine on shit. And I wonder if it has to do with stuff like this. Like if I would have read any...
Yeah, so they can do this shit.
Yeah, if I would have read past Supreme Court decisions and a Supreme Court justice were to start writing, well, actually, even if they satisfy this is what I think, blah, 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 I think I would have said, why the fuck are you writing on this? I think a phrase I've used commonly in the past is, this is even a question before the court. You have no business writing on this. This is dicta. This isn't part of the whole... Why are you writing on this? This doesn't make any sense. I don't know why you're addressing this now. And I'm seeing now here in Alito's opinion that because the court was silent on that issue, that wasn't directly before the court, the argument could be made that a activist judge in the future could say, well, they didn't actually write shit about what could have happened, and now I'm going to tell you what should happen because they didn't write on it. Maybe. I don't know if
so
that's a good reason to
that's
write.
maybe why they do a spiel.
Sometimes maybe, but there's like back and forth. You can go so much on random shit.
And because of this, Alito can quote mine from every single one of these cases, even if everything else in the case has nothing to do with it or might contradict it. He can get these quotes.
Correct. So like imagine going back to mom and dad. Imagine if mom would have ever said, like, if you take me out to a steak dinner, that'll be enough. I love steak. I would be happy to go out for steak. Yes, please, next time just a steak dinner. But if mom just says every single time you take her to a fast food place, this sucked, fuck you, this sucked, fuck you, this sucked, fuck you. And then eventually in the future you want to argue with mom, I could have taken you out to the Outback Steakhouse and you would have been happy. Mom can go, really? Go back and look at any of the times I complained about the fast food place you took me to and show me in there where I ever said a single time any steak dinner would be sufficient. And now you can't. Now you're fucked because every time mom shot down your dinner plans, all she said was, not good enough. You didn't say shit. Yeah. So now in all of these past cases related to the Voting Rights Act, there was never a comment made on whether or not simply satisfying the Voting Rights Act is a compelling reason to have a racially gerrymandered thing because the courts never addressed that question because they didn't even pass the threshold. The state gerrymandering maps didn't even pass the threshold of satisfying the Voting Rights Act. They've been silent on that question, which now gives Alito the ability to talk about it here. And Sotomayor and Kagan and everybody else, I'm guessing for the rest of this, when they go to write their response, they're not going to be able to quote anything from the past court on it because the past court didn't comment on it. Well, maybe they did, though. I guess we'll send their responses. But that would be maybe one reason why courts opine on things, maybe. But I'm sure there's a million. Whatever. But okay. Again, we did not need to resolve this question because a constitutional reading and application of the act did not require the district at issue. And again, in Wisconsin legislature, we once more assumed that complying with the Voting Rights Act is a compelling interest. Well, it sounds like the court did write that there if it's a quote. But because the Wisconsin Supreme Court had not properly analyzed whether the act required the map at issue, we remanded for the court to undertake a full strict scrutiny analysis. This was the legal framework in place when the lawsuits involving Louisiana's congressional districts were filed and litigated in the lower courts. Alito gave us pictures. As noted earlier, the underlying litigation in this suit resulted from Louisiana's response to the population changes disclosed by the 2020 census. The subsequent reapportionment of House seats among the states left Louisiana with the same number of seats, 6, that had previously been allocated, but due to shifts in population, the state needed to recalibrate its districts. In 2022, Louisiana enacted a new map, HB 1, Homeboy 1, that closely resembled its immediate predecessor. Homeboy 1, like its predecessor, included only one district in which black voters were a majority of the voting age population. In the above maps, it is the bat-shaped District 2 that includes much of New Orleans, blue in Figure 1 and yellow in Figure 2. As soon as Homeboy 1 was enacted, lawsuits were filed in the Middle District of Louisiana asserting that the map violated the Voting Rights Act by packing large numbers of black voters into a single-majority black congressional district and cracking the remaining black voters among the other 5 districts. After the suit was filed, the Robinson Court issued a lengthy opinion concluding that HB 1 likely violated the Voting Rights Act by failing to include a second majority black district. The court thus entered a preliminary injunction requiring Louisiana to implement a new map before the 2022 election, which was less than 6 months away. Louisiana objected to the decision and promptly appealed, but because of circumstances outside the state's control, its appeal ended up in limbo. This court granted certiorari before judgment and held the case pending a decision in Allen. Nearly a year later, after deciding Allen, the court dismissed the petition as improvidently granted and remanded the case to the Fifth Circuit to consider Louisiana's appeal in the ordinary course. Improvidently granted. What, as in it was granted incorrectly for not good reasons? Improvidently, Jesus, is an adverb describing actions taken unwisely, carelessly, or without foresight for future needs. Jesus. Okay. The court dismissed the petition as improvidently granted and remanded the case to the Fifth Circuit to consider Louisiana's appeal in the ordinary course. By that time, the 2022 election had passed, and the urgency that had justified the preliminary injunction was no longer present. In a tentatively worded opinion, the Fifth Circuit held that the Robinson District's court decision was valid when it was issued, but that the preliminary injunction was no longer needed. Hold on one second. Okay. So that preliminary injunction was active through the 2022 election. So the challenge to that, what they claimed was a Voting Rights Act non-compliant map was not implemented through the 2022 election. It was enjoined by the district court. Okay. All right. Held that the Robinson Court decision was valid when it was issued, but the preliminary. Okay. In the absence of urgency, the Fifth Court remanded the case to the District Court with instructions to give Louisiana time to draw a new map. If Louisiana failed to do so, the Fifth Circuit suggested the District Court could proceed with a trial on the merits and, if needed, remedial proceedings. After the Fifth Circuit's remand, Louisiana did not have many options. In the Robinson decision, the District Court held the plaintiffs were likely to prevail. After the Fifth Circuit's remand, Louisiana did not have many options. In the Robinson decision, the district court held that the plaintiffs were likely to prevail on their claim that the Voting Rights Act demanded the creation of a second majority black district. So if Louisiana refused to adopt such a map, the district court would likely draw one and mandate its use. Wishing to avoid that outcome, Louisiana decided to draw its own map. After a deliberative process, Louisiana enacted the map at issue in this suit, SB 8. Okay. I don't know.
It seems like we need individual or independent coalitions to come in and do the maps. This seems really retarded.
Well, maybe these are. Wait, real quick. In the Robinson decision, the district court held that the plaintiffs were likely to prevail. Likely to prevail on the success of a thing is an element for satisfying a preliminary injunction requirement. Why does this matter? They did prevail if they won. So why are we talking likely to prevail? Are they saying likely to prevail on appeal or something? Or I don't understand that. I don't know. Okay. Maybe that, I don't know. The issue with all of this is that you're in you're trying to satisfy a law. I don't know if this is a hot take or not. This might be a really conservative take. I don't know where I'll be by the end of this, is that I don't know if this law should have been passed like this or if we needed a constitutional amendment. Because we're relying on, it feels like a lot of, what's the word I'm looking for? Not a penumbra of rights. When you're doing a, there's a phrase, something statutory interpretation. There's a legalese phrase.
What are you trying to say?
Where you're reading stuff that's like a natural consequence of an amendment, but it's not written we don't have a right to privacy, but there's a way to read, and there's a name for this, some kind of statutory construction or legal something. Is it construct? There's a right to privacy. Necessary implication. No, this is like a legal, it's a legal phrase. Penumbra, I feel like a penumbra of rights is like when you are deriving rights from like multiple, like that's one phrase you can use, but there's something else that I feel like I'm looking for. Fuck.
Oh, fuck. I know what you're talking about, but I don't know the word.
Like it came up a lot in the abortion. Oh, that might be it. Thank you. Substantive due process, maybe? I think, yes, that is the phrase I'm looking for. I don't know if I applied that correctly. I feel like I learned this before I knew anything about law. Substantive due process is a legal doctrine under the 5th and 14th Amendments, holding the Constitution protects certain fundamental unenumerated rights from government interference, regardless of procedures followed. It prevents arbitrary government action by requiring a sufficient justifiable purpose for restricting liberties such as privacy, marriage, or family decisions. Okay, substantive due process I'm looking for. There are certain things in the Constitution where we get like rights, but we have to read them into kind of like how they are, like what the Constitution guarantees. Like, fuck me. The right to an attorney, that's not in the Constitution, right?
I think it is.
Is it? Explicitly?
Well, no. I think you're right. It's
Yeah.
it's an example of one of those. Yeah.
I believe
'Cause
that...
you have the right to counsel. Yeah.
Wait, I'm retarded. Am I? Fuck. Maybe not. That might be the 6th Amendment. Hold on. Fuck.
Oh, no. Yeah, it is actually enumerated.
In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state when the crime shall have been committed, which is to be confronted with the witness against him, to compulsory process for obtaining witness and the assistance of counsel for his defense. Okay, I don't know if this would count as like a substantive due process, but when it says the right to an assistance of counsel for his defense, like the idea that the state has to provide that for free, if it's that it has to be provided for free to the accused. I don't know if that's technically written in here, but like you would assume it would have to be.
Yeah.
It would have to be.
Yeah.
You would read that into that. It has to be. Otherwise, the right doesn't really exist if you don't read that part into it. And I believe that when you get into like rights to privacy and stuff, that's where you get a lot of those from. Is that like, well, reading these amendments, you kind of this naturally follows.
The word you were thinking of was not substantive due process. It was unenumerated rights.
Well, substantive due process deals with unenumerated rights. Yeah, but this is
Yeah.
But so I believe, or just in my, I'm giving
People are talking about the latest.
Shut up, bitch. It feels like this Voting Rights Act thing tried to get at some kind of substantive due process or something related to like the 14th and 15th Amendment, saying like, well, here's a way, like in order to make it so there's not racism, we might have to do a little bit of racism. And you could argue maybe that there, like a fair reading of the 15th Amendment would provide for that. However, maybe there should have just been a new amendment. So I'm sorry. So like reading the 5th Amendment strictly, it says, the rights of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of race, color, or previous condition of servitude, right? So you could read that in a way to where it's like, oh, well, I am going to create districts that are for every landowner or for somebody that makes over a certain amount of dollars or whatever. And therefore, we're going to say, oh, well, look, now we've created districts. And somebody could say, well, hold on. There's literally no representation of like what a black voter would want in this state. And so then you could say, well, what does that mean? Well, I think we actually do need to be sensitive to race when we're creating these districts, which means you kind of are in a way denying or abridging the rights of like white voters in those states. But you could argue that in the roundabout way of satisfying the 15th Amendment, we actually kind of do need to consider race and abridge some white people so that other people aren't being abridged. But that's like I think that would be like a substantive due process argument. Like you're reading a little bit past this amendment, which isn't always bad, but like in these areas, I feel like it's so fucking complicated that you run the risk of doing this legislatively because obviously the Supreme Court could reinterpret the Constitution or the law in such a way that now it's either struck down as unconstitutional or the way it's applied is completely different. Does that make sense?
Yeah.
Okay.
We need more. We need our Congress to actually fucking work and
Well,
pass shit.
no, not here. In here, we're talking about the Constitution. Well, you could say you need the Congress to pass a constitutional amendment.
They
Those
have
are
to do
really,
that, right?
really, really hard, yeah.
Yeah, they're very hard.
Well, in this case, for the issue is with the 15th Amendment and with the section of the Voting Rights Act, is that it doesn't say that you have to intend to deny or abridge someone's vote in order for it to work. Like the 15th Amendment, whenever the 15th Amendment was passed, people's votes were still abridged, and their rights were still abridged after the 15th Amendment. That's why the Voting Rights Act was made, to enforce the 15th Amendment. And then it was later amended even after that because it was still not people's votes were still being abridged because they were just not outright saying that it was intentional. Therefore, they could get away with it.
Yeah.
And then that's why the amendment was made in 1982 to deal with the results of a particular law.
The annoying thing is that, in my opinion, and obviously there's disagreements on this based on how much of a partisan fuck you want to be, this is a thing that's easily addressed by a Supreme Court because as districts and then different circuits are all making rulings on this, eventually you kind of see where the interpretations are, and then the Supreme Court will begin to rule and set precedents for how this is looked upon. And even if in the future somebody might look back and go, I don't think the court got this right, well, that's what they said, and that's what all the legal precedent has gone by, so you kind of stand by that opinion. But if you're going to have new, I would say, activist judges come in and go, I think that the court actually got it wrong in Roe. I think that the court actually got it wrong in Miller. I think it should be like this. And you say, bloop, fuck the last 50 years of jurisprudence, fuck stare decisis, fuck all these other concepts. I'm just going to totally rewrite how we interpret this. That threatens to, in my opinion, undermine the legitimacy of your common law, of your court system. Because now you're basically saying, well, for the Supreme Court, who the fuck cares how they've applied prior cases? It could just be that a new guy comes in and says, oh, actually, fuck it. I disagree with all of that, which is not good, I think. But
that's going to happen again if the court got packed, right?
Yeah, theoretically, that's what people like or want. Sometimes, yeah. Jesus. Okay. Okay, they enacted the map at issue in the suit, SB 8. Whoof, revived Mieri. You better fucking go into hiding. Roberts is literally hunting you down right now. The fact that you would even imply that the Congress could usurp the role in a post-Chevron world where the court has explicitly made it clear that statutory interpretation is strictly in the purview of the Supreme Court and nobody else can touch that? How dare you say that Congress can inform us on any interpretation of constitutionality? Whew. Roberts is smashing your door, breaking down your door to your house right now. Okay. SB 8 retains the original majority-minority district from HB 1, above in yellow. It then adds an additional majority-minority district, District 6, above in green, to attain a majority black voting age population. District 6 connects black populations from Baton Rouge and Lafayette in the south-central region of the state with a black population of Shreveport in the far northwest of the state. SB 8 differed from the illustrative maps shown below, on which the district court relied in Robinson. Wow, so many pictures, Lito. Thank you. These illustrative maps also include a second majority-minority district, but one with very different boundaries, shown in blue in the top 4 maps and in green in the bottom 2 maps. This district connects largely urban black communities in Baton Rouge and Lafayette, with more rural black communities in the northeast corner of the state. By contrast, SB 8's District 6 connects the Baton Rouge and Lafayette black populations with the distant black population in Shreveport in the northwest. Louisiana adopted this scheme rather than the one used in the Robinson illustrative maps because it protects the Republican incumbents the state considered most important, Speaker of the House Mike Johnson, House Majority Leader Steve Scalise, and Appropriations Committee member Julia Letlow. See brief for appellant in this court case below. Not long after SB 8 was enacted, another lawsuit was filed, this time in the Western District of Louisiana. A group of plaintiffs, the Calais plaintiffs, asserted that SB 8 Calais plaintiffs asserted that SB 8, and specifically District 6, was a racial gerrymander that violated the Equal Protection Clause. The plaintiffs from Robinson intervened in the litigation, seeking to defend Louisiana's decision to draw a second majority-minority district. Because the Calais plaintiffs challenged the constitutionality of the apportionment of congressional districts, a district court of 3 judges was convened to hear the suit. The court held a 3-day preliminary injunction hearing, which was consolidated with a trial on the merits. Observing that SB 8's second majority minority district stretches some 250 miles from Shreveport in the northwest corner of the state to Baton Rouge in the southeast, Louisiana, slicing through metropolitan areas to scoop up pockets of predominantly black populations from Shreveport, Alexandria, Lafayette, and Baton Rouge, the court concluded that the map effected a racial gerrymander that violates the Equal Protection Clause. Judge Stewart of the Fifth Circuit dissented. The state of Louisiana and the Robinson interveners appealed the decision directly to this court, and the court noted probable jurisdiction. Appeal the decision. Okay. When it says that the court concluded that the map effected a racial gerrymander that violates the Equal Protection Clause, does that mean they did engage in the rational basis review? I imagine they must have.
It's just saying that it was.
Well, how would you determine, in order to determine if it violates equal protection, wouldn't you have to engage in that review?
Not necessarily. That's what was happening in the previous cases. Was that they weren't considering it strict scrutiny, but either way, it doesn't comport with the VRA.
Fuck. Oh, this is the same. Okay, well. All right, hold on. After an initial round of briefing and argument last term, the court restored these cases to the calendar for re-argument this term. We ordered supplemental briefing on the following question: whether the state's intentional creation of a second majority minority congressional district violates the 14th or 15th Amendments to the U.S. Constitution. And because the state's intentional creation of a second majority minority district had been prompted by an order suggesting that such a district is required by the Voting Rights Act, our question necessarily implicated the correctness of our longstanding assumption that compliance with the Voting Rights Act may justify what the Constitution generally condemns: the use of race as a basis for government action. This question was pending in several lower court cases, but in light of the potential impact of those cases on upcoming elections, we concluded that resolution of the question in this suit was appropriate. In considering whether the Constitution permits the intentional use of race to comply with the Voting Rights Act, we start with the general rule that the Constitution almost never permits the federal government or a state to discriminate on the basis of race. Such discrimination triggers strict scrutiny, and our precedents have identified only two compelling interests that can satisfy that standard. One compelling interest, not relevant here, is avoiding imminent and serious risks to human safety in prisons, such as a race riot. The only other compelling interest we have found is remediating specific, identified instances of past discrimination that violated the Constitution or a statute. To rise to the level of a compelling state interest, an effort to remediate past discrimination must satisfy two conditions. First, the discrimination must be identified discrimination. In other words, the state or federal government must identify the specific instances of past discrimination that it aims to remediate, and, in light of that specification, must determine the precise scope of the injury it seeks to remedy. The states and federal government have no compelling interest in generally remediating past discrimination in a particular industry or region or the effects of societal discrimination. Second, after identifying the specific instance of discrimination, the institution that makes the racial distinction must have a strong basis in evidence to conclude that its remedial action is necessary. Our acceptance of race-based state action has been rare for a reason. Distinctions between citizens solely because of their ancestry are by their very nature odious to a free people whose institutions are founded upon the doctrine of equality. And in redistricting, where the state assumes from a group of voters race that they think alike, share the same political interests, and will prefer the same candidates at the polls, and engages in racial stereotyping at odds with equal protection mandates. The question before us now is whether compliance with the Voting Rights Act should be added to a very short list of compelling interests that can justify racial discrimination. To answer that question, we must understand exactly what Section 2 of the Voting Rights Act demands with respect to the drawing of legislative districts. We therefore turn to the text of that provision. As amended in 1982, Section 2 states, no voting qualification or prerequisite to voting or standard practice or procedure shall be imposed or applied by any state or political subdivision in a manner which results in a denial or abridgment of the right of any citizen of the United States to vote on account of race or color, as provided in subsection B. A violation of subsection A is established if, based on totality of circumstances, it is shown that the political process is leading to nomination or election of the state. Okay, this is what we read earlier for the law. This is not the easiest language to parse, and we will therefore break it down in steps. Beginning with subsection A, we take as given that a legislative districting map may constitute a standard practice or procedure. If that were not so, there would have been no statutory basis for any of our Section 2 vote dilution cases. Therefore, subsection A means that a redistricting map may run afoul of Section 2 if it results in a denial or abridgment of the right to vote on account of race or color. With that established, subsection B explains when such a denial or abridgment occurs, when the political processes leading to nomination or election are not equally open to participation by members of a racial group of voters, and that they have less opportunity than other members of the electorate to elect representatives of their choice. In this complicated verbal formulation, the key concept for present purposes is less opportunity than other members of the electorate to elect representatives of their choice. This language sets a baseline against which to assess the opportunity of minority voters, the opportunity that other members of the electorate have to elect their preferred candidates. To understand this baseline, we must nail down the meaning of three terms: less opportunity, other members of the electorate, and elect. Other members is where a lot of this decision is going to turn on. Hold on. I'm going to order food. I'm hungry. How far are you in your Lego build, man?
I'm like halfway now.
Wow.
Not bad.
Well, aren't you cool?
What are you ordering?
You know, I'm on a McDonald's kick right now, so.
Okay. Some nuggets?
My chicken nuggies, hell yeah.
I hear that.
Hi.
Hi, what's up?
What's up?
Nothing.
Yo.
Cool.
What are you doing?
Reading a Supreme Court ruling.
Fuck me, bro.
You're
This
gonna be
morning
very
starts
bored.
with fucking Mr. Mooten just not. You know what it is? He just wants to fucking do Legos. That's it.
Wow.
He doesn't give a
That's not
fuck.
true.
All
I
this.
wanted to do politics, and you were there fucking whinging for an hour.
Oh!
No, it was
he
more
called
than
you a
that. It was
whinger.
3 hours of
Whinging.
listening to Trump fucking ramble.
It was
nonstop.
an hour of him rambling, which was awesome, by the way.
It wasn't. It wasn't.
Listen, we like different things. It's okay.
No, you don't like that, and I don't like that. You were playing Legos. Politics is interesting.
What do you mean I was playing Legos? You fucking retard. I wasn't touching the Legos.
You were touching the Legos.
No, I was taking notes.
You were taking notes on Trump rambling.
Yes. I can show you the book.
I want to know what he was rambling about.
Well, it's not always what he's rambling about because I know the 50 times he says it. Hold on.
He's gonna show us his notes. It's, hey, what if I use this piece right here? And what if I change the instructions so that actually...
It was there was these poor kids that were surrounded by Trump, okay, and they couldn't do anything. They were
I'm ready.
I'm
ready. Just waiting.
They were there for, I guess, the presidential fitness shit, and Trump was just fucking talking about nothing for an hour, and the kids were like, "The fuck? How do I leave? Can I go?" And Trump fell asleep halfway through.
Trump said 4 miles, 1 shot, disabled the engine in the tanker. It seemed like a bit of a
That
leak
was
there,
at
so
the
I wrote
end.
it down. Okay, that's not true, first off. Second off was 42,000 protesters dead. Apparently he was talking about snipers there, where apparently there were like 200,000 women out there, and he was saying like snipers were shooting him in the fucking head. He also said Iran wants a deal, not what they say in public, but you know, in private they're saying that. He said 60% of the oil from Hormuz is China gets their 60% of the oil China gets from Hormuz, the Strait. Apparently Japan gets 90% of their oil from there. Don't know if that's true. Iran's inflation's at 150%. Apparently they're not paying their soldiers. Apparently this is being rumored in multiple sources. There's new trade routes maybe happening because they're learning habits. Maybe that. He talked about 47 years again, and he said that they knocked down 111 missiles at their ships in the Strait.
What you're reading right now is the daily briefing that
Yes.
what's his face gives to you.
Okay.
Okay, all right.
Give
I don't
me,
know.
give
You
me
know,
10
triggering.
minutes, and let me just get through section 1 of this, and then I'll be done. Okay. In isolation, opportunity. Okay. So we're trying to figure out what less opportunity, other members of the electorate, and elect mean. In isolation, opportunity could refer to either a desired outcome or a chance to achieve that outcome. As used in Section 2B, however, opportunity must mean a chance to achieve a desired result because the Voting Rights Act does not guarantee equal outcomes. Accordingly, less opportunity must mean a lesser chance. In ordinary usage, less opportunity often takes on such meaning. One might say, for example, that men under 6 feet tall have less opportunity to play in the NBA than those who stand at least 6 feet 7 inches, the current median. The next term, other members of the electorate, specifies the comparator to be used in determining whether the group protected by subsection A has suffered or is threatened with suffering less opportunity to elect representatives of their choice. In conceptualizing the members of this comparator group, we may think of a randomly selected member of the electorate who has particular voting preferences, or we may think of a randomly selected group of voters who share certain voting preferences. These voting preferences may be based on a candidate's party affiliation, ideology, stance in a particular policy issue, personal charisma, or some other characteristic or set of characteristics. But whatever they are, the situation of these randomly selected voters must be compared with that of minority voters alleged to have suffered vote dilution. Is that true? Randomly selected? I would have assumed that you were comparing a group against another group of the same kind. That would have been my assumption.
You would think so, right?
Are not equally open to participation members of a class of citizens protected by subsection A, and that its members have less opportunity than other members of the electorate to participate in the political process. Huh. That's an interesting reading of that. I would have never assumed that. I would assume that, like, if you have a large Mexican voter base or a large black voter base or a large Asian voter base, that the large Asian voter base has their interests represented the same way as the countervailing white voter base or other racial voter bases, not a random subsection of, or not a random cross-section of the electorate. I don't know if there's any case law or any speeches by Congress at the time that would justify that, or if he just says that, and we're just...
You want me to spell that part for you?
What?
He's just saying it.
Yeah, but I feel like that's an important distinction. Huh. Interesting. Okay. Wait. Okay. This brings us to the final term, to elect, as used in Section 2B. This term must refer to the achievement of electoral victory by casting a ballot. Putting all these terms together, the baseline is the chance enjoyed by non-minority voters to secure the election of their preferred candidates. What, then, is the chance that any given non-minority voter or group of non-minority voters has to secure the election of a preferred candidate? The answer to this question depends on the voting preferences of other voters in the district. Where is the statute? Hold on.
On that particular sentence, it's more accurate to the reading that you were saying, or the what I would say is the correct reading, because it's saying members of the non-minority is the baseline that you need to compare the minority's opportunity to.
Well, when he says, what then is the chance that any given non-minority voter or group of non-minority voters has to secure the election of a preferred candidate, that the non-minority voter thing there still seems to be like compared to a random person. as opposed to compare it against like the majority group or a non-minority group. But I don't know. The answer to this question depends on the voting preferences of other voters in the district. Is that true? Like if I were to say we're going to pass maps and they happen to disenfranchise every black voter, it sounds like under his rationale here, we could say, well, all the black people voted for this candidate, and hey, guess what? The white people in these other districts, they voted for that candidate too, so it's fine. That sounds like the argument he's rolling with here.
Yep.
To answer this question was on the voting preferences of other voters in the district. For example, in a district where most voters prefer Democratic candidates, a Republican voter in that district will have a low chance of securing the election of his or her preferred candidate, but that chance would be substantially higher if the district were instead filled with voters who prefer Republican candidates. The roster of voters who end up in a given district depends in turn on the districting criteria used by the state in drawing a legislative map. I don't think we care about that, though. We don't care who you prefer. We care about the class of people making the preference, right?
Yep.
Are not equally open to participation by members of a class of participation, and that its members have less opportunity than other members of the electorate to participate in the political process and to elect representatives of their choice. Okay, Okay. The roster of voters who end up in a given district depends in turn. Okay. If a districting map is produced by computer, as is generally the case today, we may think of all the parameters in the algorithm that the mapmaker uses. One necessary parameter would be the number of districts required by law, and another would have to be a range of inter-district population variations that is small enough to comply with the one-person, one-vote requirement. The algorithm might then go on to lay out and assign priorities to whatever additional permissible criteria the legislature chooses to use. For example, the legislature might want to minimize changes in the prior map, avoid districts with contiguous territory, and avoid splitting counties or municipalities. It might impose a certain standard of compactness aimed to protect some or all incumbents or promote the prospects of a particular political party. When this algorithm is used, the map it produces may place a particular voter or group of voters in a district in which a majority generally agrees, generally disagrees, or only sometimes agrees with their voting preferences, but in any event, the opportunity of these members of the electorate to contribute their votes to a winning cause is whatever opportunity results from the application of the state's combination of permissible criteria. That is what our randomly selected individual voter and a group of voters can expect regarding their opportunity to elect a preferred candidate, and under Section 2, a minority voter is entitled to nothing less and nothing more. Interesting.
Saying, oh, you're mad that your district became majority white? You can still vote, can't you?
Or at least in a proportion enough that like the broader electorate is representing. So basically, make a bunch of white friends and hope that they're voting in the way you want, and then you have no more case because there's at least another... Yep. Interesting. Okay. One thing that I hate sometimes about some of these Supreme Court decisions is like, so we're about to read 90 whatever pages, or I will over the next day or two. Sometimes there'll be like 2 pages. The immunity decision was like this, where they like, the most like divisive part of the ruling is kind of like just dealt with in a few pages. And then they go on to make all the analysis after that. And it's like, well, obviously, if we agree with how you define the statutory language here, I mean, everything else kind of logically follows. So I don't know what the fuck he's going to write about for the rest of this. Because, I mean, if we agree that the only thing that matters is the person you're voting for is ultimately voted for also by white people or in other districts, then sure, who cares? But, like, it sounds like for this, like, theoretically, I could challenge the districting in any state now if I get all the black voters in a state to vote one way that I know the white voters aren't going to vote with. Now I can claim, well, look, they all wanted to vote one way and the white people in other places didn't, so now we need to redistrict. Which, I don't know, this sounds kind of silly. I don't know. Okay. All right. We'll continue this tomorrow.
That's it? You didn't even get to the good part, man.
Listen, a lot of bullshit here. Okay.
It's a lot of bullshit.
Jesus. Sheesh. Shut the fuck up, you little punk. Fuck you. All right. We got to check up on our boy.